Section 185 to 189 of the Labor Relations Act, LRA, provides protections for the worker who is unfairly dismissed. Because job security is important, dismissal should always be the last course of action. Employers must try to resolve problems rather than dismiss workers.
How do I know whether I have been unfairly dismissed?
You can go. I don't have time to talk. You will be paid what is owed.
A dismissal is unfair if the employer did not follow a fair procedure before dismissing the worker, or there was no good reason to dismiss the worker.
Can a boss dismiss you if you broke a rule that you knew about and nothing can be done to correct the situation?
Misconduct. In other words, your employer can show that you broke a rule that you knew about and understood, and that the rule is applied equally to all workers.
You know you are not allowed to use a machine for which you are not trained. Now a worker has been injured.
In other words, that it would not be possible to correct your actions through the giving of a warning.
Can a boss dismiss for poor performance?
Only if an employer can prove that the worker was aware of the required standard and did not fulfill what was required of him. However, the employer must also give the worker a real chance to improve to meet the standards, like providing training, for example.
Can a boss dismiss a worker if a worker is not able to work due to ill health?
In this case, the employer must try to accommodate the worker, especially if the incapacity is temporary.
Yes, here is a vacancy in the parking room. This job will be a little easier.
But before dismissing a worker for misconduct, poor performance, or incapacity, the employer must give the worker the chance to tell his or her side of the story. The worker must be told clearly what the employer's complaint is, in a language he or she can understand. The worker must be given enough time to prepare for the hearing, at least 48 hours. And the worker must be allowed to have someone to assist him or her in the hearing, and an interpreter if necessary. Employers may not dismiss workers for exercising their rights under the LRA, or for participating in procedural strike action, for pregnancy, or for any reason which is discrimination. Should they do this, the dismissal is automatically unfair and must be referred to the labor courts. Workers who have been unfairly dismissed must refer their dispute to the CCMA within 30 days of the dismissal. Workers who are covered by a bargaining council must refer the dispute within 30 days to the bargaining council. You can phone the Casual Workers Advice Office if you are not sure if you are covered by the BCEA, a sectoral determination, or a bargaining council.